Hello, I'm Becca Pitts, and I have with me Liz Johnson today, and we are going to talk about wills and trusts and the ins and the outs and the yeses and the nos and the what way is up with all of that estate planning. So, thank you for joining me.
Thank you for inviting me.
Absolutely. So, let's open a can of worms, shall we?
Let's do it.
Okay, perfect. What's the simple definition? What are we talking about? What is a will? What is a trust? What do we need to know about them and the difference and all of that in between?
Right. So I think the most important thing to know is that you don't actually have to know as much about them as you have to know about your estate. So a will is just a document that when you pass away, it directs the disposition of your estate. It says who's going to be in charge of what. It says who's going to get what. Only in relation to assets that actually go to probate. A trust is a document that while you're alive, it can be revocable or irrevocable, which determines your level of control, and it gets very complicated at that point because you can pick different things. But where you properly fund it, meaning you create the trust and then you actually put assets into the trust, that's a step a lot of people skip.
I've heard that, yes. I've heard that. Like, I've got a trust, cool, what's in it? Well, I haven't done that part yet.
Yes.
Sort of an important part. You can't have, it's like having a safe or a safe deposit box and you don't put any of your money or valuables in it.
Correct.
So that's an important
nice
step.
to have a safe, but that's a trust. The document itself is a safe.
Okay.
But if you never put anything in the safe, you can't get mad when your house burns down and your fireproof safe didn't protect your items in the kitchen.
Right.
So.
Right. Okay.
And a lot of people don't realize, because it's not so tangible, they can write on a piece of paper like, I want these items in my trust. Ta-da, they're in my trust.
Mm-mm.
That's not, you actually have to do the title change. And sometimes it involves reporting, sometimes it involves going to the bank. In the case of an irrevocable trust, it might mean getting an EIN number from the IRS and then going to the bank.
Okay.
So it gets complicated, but essentially it is just a vehicle that holds your assets while you're alive, or after someone has passed. It can be a third-party trust. I'm gonna try not to be complicated. and really, we're probably talking about a revocable living trust.
Okay.
So that is where people put assets while they're alive, and you can direct the disposition of those assets while you're alive. You can use them for whatever you want, and then when you
define
pass,
disposition.
when you get rid of them, so you can use them for any of you can use them for anything that you need now. You can pay your bills, your mortgage, go on vacations.
So it's very fluid. While you're alive, it's fluid,
Mm-hmm.
and you can move things in or out of it as long as it's revocable. Irrevocable is different.
Right, we won't get into that. There's a lot of different kinds. There's kinds you control, there's kinds that are controlled on your behalf, so and then the level of control you have over an irrevocable trust is different. But I would assume that most people, what they're talking about is the will versus the revocable living trust.
Yes, okay.
So in that very limited, this is not legal advice for anyone, but this is educational. The very limited thing that we're talking about right now is a revocable living trust. And there are all kinds of trusts outside of that, like a credit shelter trust, Q-tip trust. There are trusts for tax planning. There are trusts for long-term care planning. There are trusts because maybe you need to protect someone in your family. There are trusts for people who have special needs and are on state benefits. Many, many different kinds of trusts. Not talking about all those.
Okay.
Revocable living trust and a will. So the revocable living trust, you can use it however you need to while you're alive and take things in and out of the trust.
Mm-hmm.
And then when you pass, there's a successor trustee. They can just distribute the trust according to the terms of the trust. So you have your beneficiaries in the trust.
Mm-hmm.
You don't have to go to probate for anything that's in the trust.
So is probate the main difference, that the reason that you might want a trust as opposed to just a will?
There's also privacy and ease. Sometimes it's easier for people. There are a couple of different reasons that you would want a trust instead of a will. And this is where a lot of times people think they're coming to me to prepare a will or a trust. I do prepare those documents,
Mm-hmm.
but you're coming to see me for an estate plan.
Okay.
And most people think that the estate plan is strictly the documents, but there's planning that goes into it.
Mm-hmm.
So what we have to look at is, what are all of your assets?
Mm-hmm.
How are they titled? What are all of your debts? And if we did nothing, what's going to happen and what are the tax consequences going to be right now, if any?
Okay.
And then you tell me what you want to have happen. So some ways, I think that rather than explaining what they are, sometimes it helps to have just examples of where things have been.
Yeah.
So I was doing a probate. I didn't draft the will or the other documents. I didn't get to consult with the person who passed away. But they had done a will, and they split everything between their children equally. However, she had joint bank accounts with one of her children. Joint bank accounts don't go to a will unless you have super will language, but then we're also going down a very much more complicated rabbit hole.
So for standard purposes
of a will without super will language, those accounts never go to the will.
Because they just become the ownership of the joint
tenant with rights of survivorship. So when you're estate planning, you can't make any assumptions. And I will say that you can have verbal instructions, but those are not going to do anything when you pass away. It's going to go according to how your documents are. So that child didn't have to share that money. Now you've removed that asset and you're going to divide the rest of the estate in 3 equal shares, but of your whole estate, one child is going to receive a larger share. And if that's not your intention, then we need to adjust your plan. There are ways that you can defeat the plan that we develop, which a lot of people, if you don't meet and understand that every bank account you're opening, every pay on death beneficiary you're assigning, every document that you sign that changes the status of your property is part of your estate plan and can wreck the estate plan that you're trying to have.
So then as you're going through life and you have this estate plan and it's great, and then you buy a vacation rental,
right?
How do you make sure that that's a part of your plan? Do you schedule another appointment with your attorney, or do you title it a certain way, or how do you keep your plan up to date?
I never want people to part with money they don't have to, so I don't always go to an attorney right away. If you understand how your estate plan works and you understand how to title that document in a way, or to make that purchase in a way that suits your estate plan, then you don't have to go see an estate plan attorney. I think that I don't necessarily recommend, depending on how complicated your estate is, that you skip an attorney, but just simply asking a lot of times, like if you and I were on an account together, we could go to the bank and say, what happens if Becca dies? And they could tell me, oh, well, the account would go to Liz. And you can go, hang on, it was supposed to go to my kids. So now we have an opportunity to fix it, and we can say, how do we make that happen? Maybe we just change the death beneficiaries, but because we're joint tenants, maybe we have, with rights of survivorship, maybe we have to separate our accounts or try to do something else, so that when we say what happens when Becca dies, you like the answer.
Right.
And if you can't, then maybe you do engage an estate planning attorney to help with that. The other thing is then we would ask, what if Becca and I both die at the same time? Then what happens to the account? And maybe the entire account goes to your kids, and I'm like, well, hang on, that's not what our agreement was. That's not what our agreement was. So this is our opportunity to fix it on any asset that you own where there's someone else, like a bank. Obviously your house is more complicated,
right?
When you say what happens to it, because there isn't a single person you can ask. If you have a mortgage, they're gonna be involved,
right?
If you have a spouse or heirs or other loans or liens, like it's a harder.
And with the complications or complexities, I should say, with different family dynamics, like that's a whole different. I mean, I guess that's why we deal with probate. But if you plan it very carefully and very thoroughly, then can you avoid probate even if you have a will and a trust? Or can you, is it possible that you won't avoid probate even if you have a will and a trust?
It's always possible you won't avoid probate.
Okay.
So, but you can structure a lot of things so that you can. And when people say, if you're in Washington and that's where your estate resides, Washington probate isn't as terrible as some other places. And I'm not casting disparage against other places. Every place is lovely. But you know, other states have different rules where probate is more expensive or more complicated, and Washington has a pretty streamlined process. So I never want people to avoid probate when there are other trade-offs that they have to give up, such as dispersing the assets equally. There are transfer on death deeds for properties in Washington. So if it's me and you, and we've been friends and we've shared the house forever, I can make a transfer on death deed to you. It passes to you outside of probate. But if I have 5 kids, they now become 1/5 equal owners. You need 5 people to make an agreement on the sale.
And if one of them dies, but they have 2 kids, well, guess what? Now there's
now we have 7 people involved. Exactly right. So this is your area, right? Because you do real estate. You show up and someone's like, I own the house. And you're like, but you don't.
But actually, you own this much of the house and we need these other signatures. But it's not, well.
And also, Becca, I live there. So we're going to use the I touched it last rule, which is not actually a law.
But what if you lick it?
No, you cannot lick it and you own it. What an interesting law that would be. So, yes, you do have to combat these family rule laws versus what the laws are. So maybe a transfer on death deed avoids probate, but creates a different headache. You don't have one decision maker. Okay. You don't know if someone is going to die before a resolution to your estate occurs. Maybe there's minor children involved now, and now we need someone who can exercise their interest. So yes, people come to me like, should I do a transfer on death deed? And I'm like, I don't know. And they're like, you're being cagey. I'm like,
you need more details.
There is literally a negative consequence that could occur for you if I just tell you some small piece of information without understanding. Like when you say, I want to leave my estate to my child, you know, how old is that child? 21. Is that okay? Can I leave it to them? You can leave your estate any way you want to, but if they're disabled and they're on state benefits, maybe the better choice is some kind of special needs trust so that they can continue to enjoy a certain quality of life.
Because if they inherit too much value, then that disturbs what they can qualify for?
Correct. And they can lose benefits.
Gotcha.
And if they do inherit a large value, depending on their age, sometimes there's ways we can manage that after the fact, but it gets hard.
Right.
I would say, much like you, right? So if I asked you, like, what do you wish people would stop giving advice to your clients about? What do you wish they would stop telling your clients before your clients get to you?
Well, there's a lot, and I'm sure that that's probably similar to your answer. Like, there's so much misinformation, and there's infinite ways that someone could either do things right or very wrong. And so you need all of the information to help guide them and help them decide what is best for their situation.
And when a lot of times people have a singular experience, and a lot of times it's bad. You know, they remember it, they're so passionate about it, they will tell you, oh my gosh, no matter what you do, get a trust. If you don't get a trust, everything will be over. You will spend so much on probate, the state will take your money, you will spend years in probate. And the simple truth is that's not accurate. I do a lot of probates with a will. We're done in 4 or 5 months.
Right.
It's over.
Yeah.
But when you have a bad experience, you're much more vocal and you're much more scared. And a lot of times when people are not having as great of a time, there's a strange circumstance that occurred. Or simply a failure to actually plan or meet with somebody who can help you plan correctly. Because you say things like, well, Becca, you're going to get my house when I die. But I've done no planning and you are not in the position that you would be the next to inherit. So we're relying on the state to pick it.
So if you want to have good control over what happens to your assets and they go in the order and the volume and timing that you want, you need to plan in advance, otherwise the government decides for you.
Right, Washington has an estate plan for you. If you think you don't have an estate plan, you are inaccurate. If you are a Washington resident, and if you are a resident of most states, your state has a plan for what will happen with your assets if you pass. If you are okay with them picking and you believe that their plan works for you, then yeah, you don't really have to do anything else. Sometimes it makes it easier, but...
So that actually sparks a question for me. When is it time to start thinking of estate planning? Is it as an age, or is it an amount of assets, or is it like what is a good benchmark to decide it's time for me to 18?
Yeah, once you start opening any account or you have any resources, I mean, if you think about it, so what if you have 2 parents, let's assume, this anomaly occurs. But maybe you're not close with one of them, and if something happens to you when you're 18 and you pass away, maybe you don't want this parent to have your ashes or control of your disposition. You want to pick that it goes to this parent. Maybe if you have $5,000 in a bank account, you want it all to go to the parent that helped you or took care of you, not the parent you're estranged from. So you want to make sure that you're picking that person. If you're in an accident, which is not really a will or trusting, right, unless you die. But let's say you can't make decisions, you're nonverbal, you're in a coma, you're
somehow compromised.
A guardian or conservator could be appointed for you if you haven't done a power of attorney. And it could be the parent you don't like, or it could be an adult you don't like, or it could be a stranger you don't like. A power of attorney sort of moves you out of that and gives someone the ability. And a power of attorney is such an infinitely customizable document. You can limit when it goes into effect. You can choose certain activities that a person can do.
Medical versus financial versus...
And limited medical decisions and limited financial decisions. Maybe you give a power of attorney for just one account or something like that. Sometimes people try to here's how my family did it. We just added people jointly onto our account. And that is great. And I used to ask dumb questions like, do you trust the person? And it's like, implicitly, many times people have stolen money from other people that have been joint account. These two people were good friends. They dealt with each other fairly. Everything was fine. But one of them got sued. It wasn't a fair lawsuit, but they lost. There was a judgment. The judgment applied to the joint account. So even though you didn't take the money, I didn't take the money on purpose, this judgment then took the assets from the account. And what do? I mean, just never get sued.
Ideally, that is the way to live.
Right, so just try that. But you can't always control some of these third-party factors that occur. So adding someone jointly to your account creates a risk that you will not have access to your own assets. Or that you could inadvertently, I would feel horrible if I was holding money for you and
I lost it because of XYZ,
right?
And now you're out because of my either bad circumstance or poor decision making or something. But that's
you don't want ownership to be an issue of your assets.
Right.
I don't want ownership of my assets to be an issue. I want to own them.
So ideally, as soon as you're 18, you should start making plans. If you don't bridge that gap at 18, as soon as you have something to lose or have a specific, you didn't like that.
As soon as you're 18, you have something to lose control of something.
Right. Yeah. Okay. So I guess my point is though, if for whatever reason you can't get it done at 18 or you choose not to do it at 18, it is at least important to do it as soon as possible. Right. Especially when there's things gathering and you want to make sure that you have a choice in where they go, or maybe more importantly where they don't go.
Right. Okay. And who's going to make decisions for you? A lot of people get worried about the estate plan and the trust. I'm more worried about who's making decisions while I'm alive.
Yeah.
The power of attorney is the king document for me.
Yeah.
To a certain extent, you get what you get when I'm dead. But when I'm alive, I want to know who's making my medical and financial decisions. I want to make sure that it's somebody who understands my financial plan and is going to make those choices. But if you don't do it as soon as you're 18, the next best time is immediately. As soon as you can.
Okay.
And then updates are any time that you need one, right? How big is that?
Right.
So I would say some big benchmarks are buying a large asset, inheriting money yourself, having a child, having a second child. Your documents don't always need to be updated. I consult with a lot of people who bring me their stuff. And I'm like, your documents are great, but if you still want to give me money, I'll make you new shiny stuff. We usually don't. Again, I don't take money from people that I don't need to. I don't think people should spend money they don't need to.
Good, that's why you're sitting here.
So, I think that it is about having that conversation about what you need. And if your documents are fine, your documents are fine. People get locked into the idea that a trust will avoid probate or a joint account will avoid probate. And really, you want to make sure that there's a strategic plan and how much control do you want to have over your assets versus how much do you want to pass on to people. It really is less about whatever document I prepare. Like some of them I can use in a Swiss Army way to, like there's a lot of your estate I can use to come to an outcome in a variety of ways without maybe the more traditional, we had to use a trust.
Right.
It really is about control, comfort, and what you're trying to achieve with your estate plan, and less about which piece of paper I get you there with.
So a trust is a tool, a will is a tool, a payment on death is a tool, a POA is a tool. All of these are in your toolbox, and you will help build the plan.
Right. And some tools are more elegant than others for a job, you know, but if you're out in the wild and you have a hammer and a can of soup,
Then you use a hammer to open a can of
not
soup,
the best.
and it works.
But maybe that's the tool that you had, and that's the one you could carry. So if all you have is a hammer and a can of soup,
We'll make it
let's talk about it.
Yeah.
You know, it's more complicated, but let's talk about it and see if we can get you where you need to be. Because ultimately, I think people should be able to make choices. I'm not a big fan of other people making choices for us.
Fair. Good. Okay. All right. I love this. Well, thank you so much for your time. I appreciate it. And I guess the go with is it depends. And isn't that a fun answer? But truly, it depends. There's so many things in life. So thanks for joining us, and we'll catch you on the next one.